Reputation plays a significant role in the legal profession. Since people prefer to hire a lawyer with a better reputation, a lawyer with bad reputation may even affect the importance of the entire law firm, since a lawyer is usually considered the representative of the law firm. Therefore, it is essential to maintain a good reputation. Today, we will discuss how the government, law firms, and lawyers maintain the legal profession's reputation. The first way for the government to maintain the reputation of legal professions is to set obstacles for people to become legal professionals. The three countries we discuss here require thorough educational background and period of traineeship experience to be a legal profession. In the United Kingdom, for example, an applicant needs to have a law degree with a bar professional training course and a 1-year pupillage to become a barrister. In Germany, an applicant has to complete a 2-year legal training before being qualified to take the German bar exam. And once the applicant passes the bar exam, such applicant will automatically grant a written certification that does not need to be renewed. The requirements on educational background for being a lawyer in France are stricter. An applicant needs to have a 4-year law degree and a master's degree in law. To apply for the local bar exam, the applicant will need to pass the law school entrance exam of the local bar association and finish an 18-month traineeship in the school before actually being qualified to be a lawyer in France.
The second way that the governments use to maintain the reputations of the legal professions is to set up some principles and requirements for the legal profession. The essential requirements are the ethical requirements. These rules can also be understood as clients' expectations for their lawyers. Therefore, we can find many similarity in the ethical requirements of lawyers set up by different countries, since the client expectations are usually similar regardless of the country they are in. In the UK, there are 4 ethical requirements for a legal profession. The first one is to act to uphold the constitutional principle of the rule of law and the proper administration of justice. The second one is to act in a way that maintains public trust and confidence in the solicitor profession and legal services provided by authorized persons. The third one is to act with independence, honesty, and integrity. The fourth one is to act in a way that encourages equality, diversity, and inclusion. And the fifth one is to act in the best interest of each client. There are 4 ethical principles of legal professions in France: the principle of independence, the principle of loyalty, the principle of confidentiality, and the respect for professional secrecy. There are a lot more requirements set for the legal professions in Germany, which establishes a guideline for the legal professions to deal with various situations, from general duties like confidentiality, conflict of interest, and dealing with clients' assets, to the special duties regarding publicity, accepting, handling, and terminating instructions, the courts and authorities, fee arrangement and billing, the board, cross-border activities, and professional cooperation. For this part, we have invited our Professor Lasse Schut to answer our questions. Ajahn Lasse is a German lecturer who have met and studied with throughout LB course at Thammasat University. He has immense knowledge and experience in legal profession in Germany, as he had worked as a lawyer of IP department in an international law firm, a criminal defense lawyer, and acquired a PhD degree in law before becoming a lecturer at Thammasat University. These experiences give him a first-hand insight into the legal ethics of lawyers.
I think one of the most important aspects, of legal ethics is the relationship of trust with the client. Because when you meet a client, particularly in criminal law, you will most likely meet a person who needs help and who wants to rely on you. So you really need to be very much aware that here is a person in front of you who really relies on this confidentiality. And therefore, every communication, also via email or other communications, always need to have in mind who could theoretically get this communication, who could perhaps have access to this communication. So you will most likely have many meetings in person to make sure that this is just between you and your client. Any important information will not be put into emails, but will really then exchanged most likely in physical form, like on paper, or you will have other maybe secure ways of communication. But I think maybe that is, from my experience, something that I think is most important, that because often clients don't know what is a confidential way of communicating. They may even want to send you everything via email. So then you have to really stop. We need to do it differently. So it's then really also the duty of the lawyer to inform the client about these confidential ways of communication. And I always witnessed my colleagues and my partners to be very responsible in that regard. But I think nowadays this has even become more important because of even more technological advancement and possibilities to, for example, get access to communication. Just one highlight perhaps, but I think in my experience, one of the most important ones.
To summary, as we have already stated in our research, reputation plays a significant role in the legal profession. Logically, people will prefer lawyers with better reputation than those that don't. And not only people and clients, most governments also give this matter very significant attention. We can tell from the method they implemented to maintain the reputations of the legal professions. There are two methods. The first is to maintain the reputations of the legal professions and set obstacles for people to become legal professions. The second is to set up some principles and requirements for the legal profession. Of course, each method will vary from country to country. To give an excellent example, we have interviewed one of the German teachers of our faculty, Professor Lasse Schult, for his legal ethics experience. He stated that even though he never witnessed any violation of the ethics rule, he still knows what a German lawyer should do and behave. For example, maintaining trust with their clients or protecting their confidentiality. Otherwise, they will face punishment is always there to remind us that lawyers have an ethics act if they try to utilize any legal tools to their advantage. The professor states that it usually depends on the legal profession to be classified as a violation. Some professions like lawyers or attorneys are allowed to be one-sided and biased, still like a judge. The one that works for the public interest should never pursue any of the acts, which includes acting for political agenda or pursuing ideological goals or any self-interest.